Good afternoon and welcome to the Assembly Committee on Commerce and Labor. Secretary, will you please take roll?
Assembly members Anderson, Carter, Cole, Hardy, Howdigy, Kasama, Miller, Monroe Moreno, O'Neill, Roth, Torres Fawcett, Yeager, Urick, Marzola, Chair Marzola.
And I am here. Welcome everybody that is here with us in Carson City, those joining us in Las Vegas, and anyone tuning in over the internet. Today we will hear 4 bills: Assembly Bill 332, Assembly Bill 376, Assembly Bill 407, and Assembly Bill 450. We will also conduct a work session. We will not be taking those bills in order. I will be holding the work session first. Before we get started, I do have a few housekeeping announcements. Members of the public may provide testimony in various ways, all of which are listed on the agenda. When testifying, please remember to turn on your microphone to speak and off to listen, and also remember to please state and spell your name for the record. Committee information is available on Nellis, which can be accessed through the legislature's website. You may also watch our meetings through Nellis or the legislature's YouTube channel. We ask that public comments be kept to 2 minutes so that everyone can be accommodated. As always, I expect courtesy and respect in all our interactions, even if we may not agree. Please remember to turn off or silence all of your electronic devices, especially your cell phones. And with that, we will move on to our work session. It is not customary for the committee to take testimony or otherwise rehear the bills during a work session. However, I may invite a witness to come forward for clarification or questions during our consideration of a measure. With that, we will start with Assembly Bill 169.
Assembly Bill 169 requires that certain health insurance policies and health plans cover speech language pathology for certain purposes, sponsored by Assemblymember Yeager, heard on February 28th, and there are 2 proposed amendments listed on your bill page.
Thank you. Members, are there any questions? I don't see any. I'll entertain a motion to amend and do pass Assembly Bill 169. So moved. I have a first from Vice Chair Howdigy. Is there a second? I have a second from Assemblymember Monroe Moreno. Is there any discussion on the motion? I don't see any. All those in favor say aye. Aye. All those opposed say nay. Motion carries. I will assign that floor statement to myself. Next, we will move to Assembly Bill 280.
Assembly Bill 280 revises provisions relating to housing, sponsored by Assemblymember Howdigy, heard on March 26th, and there is 1 proposed amendment.
Members, are there any questions? I don't see any. I'll entertain a motion to amend and do pass on Assembly Bill 280. So moved. I have a first from Assemblymember Monroe Moreno. Is there a second? I have a second from Assemblymember Torres Fawcett. Is there any discussion on the motion? Assemblymember O'Neill.
Thank you, Chair. I will be voting no for this bill. There's parts of it dealing with rent control that I'm having difficulties with. Thank you, Chair.
Thank you for the discussion. Is there anyone else? All those in favor say aye. Aye. All those opposed say nay. Nay. Please raise your hands. I have a nay from Assemblymember O'Neill, a nay from Assemblymember Kasama, Assemblymember Urick, Assemblymember Cole, and Assemblymember Hardy. Motion carries. I'll assign that floor statement to Vice Chair Howdigy. Thank you, Madam Chair. Of course. Next is Assembly Bill 498.
Assembly Bill 498 revises provisions relating to motor clubs, sponsored by the Committee on Commerce and Labor, heard on March 28th, and there are no proposed amendments.
Members, are there any questions? I don't see any. I'll entertain a motion to do pass on Assembly Bill 498. So moved. I have a first from Vice Chair Howdigy. Is there a second? I have a second from Assemblymember Monroe Moreno. Is there any discussion on the motion? I don't see any. All those in favor say aye. Aye. All those opposed say nay. Motion carries. I'll assign that floor statement to Assemblymember Carter. Finally, we have Assembly Bill 510.
Assembly Bill 510 makes various changes to the regulation of accountancy, sponsored by the Committee on Commerce and Labor, heard March 28th, and there are no proposed amendments.
Thank you. Members, are there any questions? I don't see any. I'll entertain a motion to do pass on Assembly Bill 510. I have a first from Vice Chair Howdiggy. Is there a second? I have a second from Assembly Member Urick. Any discussion on the motion? I don't see any. All those in favor say aye. Aye. All those opposed say nay. Motion carries. I'll assign that floor statement to Assembly Member Urick. Thank you, members. This concludes our work session for today. 1 minute recess.
The committee will now come back to order. I will now open the hearing on Assembly Bill 450. Chair Marzola, when you're ready, please begin.
Thank you, Vice Chair Howdiggy and members of the committee. I'm Elaine Marzola, representing Assembly District 21. I'm here to present Assembly Bill 450, which revises requirements to obtain a license as a marriage and family therapist or clinical professional counselor by endorsement. We continue to experience a shortage of mental health professionals in Nevada, especially in our rural and underserved areas. In addition, as our population continues to rapidly grow, especially in our urban areas like Las Vegas, so does the demand for mental health services. However, the number of providers have not kept pace. The shortage has significant impacts on individuals' access to care, often leading to delays in treatment and increased wait times. To alleviate the shortage, in 2015, the legislature authorized a board of examiners for marriage and family therapists and clinical professional counselors to allow these professionals to obtain a license by endorsement to practice in Nevada, if they met certain requirements, of course. Since that time, it has reduced barriers to obtain a license, yet you'll hear from my co-presenters that the current process should be even more streamlined to encourage more licensed professionals to relocate to our state. Vice Chair, with your permission, I would like to turn the presentation over to Mr. Bobby Arnott with R&R Partners to go over the bill and the amendment. We also have Ms. Patricia Barton, who is joining us on Zoom, alongside with Dr. Rice, who will be joining us in Las Vegas. And with your permission, if I can turn it over to Mr. Arnott, Chair.
When you're ready, Mr. Arnott.
Good afternoon. For the record, I'm Bobby Arnott with R&R Partners, here on behalf of the American Association of Marriage and Family Therapy. Co-presenting with me today on AB 450 is Patricia Barton, Director of Government Affairs for AAMFT, and Dr. Dominique Rice, a practicing MFT who has utilized licensure by endorsement to practice here in Nevada. With your permission, Vice Chair, I'd like to first have Patricia Barton speak to the need for this piece of legislation, and then have Dr. Rice speak to her experience as an MFT in the state of Nevada. And then I will conclude the presentation by going through the bill and conceptual amendment. Yes, Ms. Barton.
Ms. Barton, when you're ready.
Good afternoon. For the record, Patricia Barton, Patricia Barton. I'm here on behalf of the American Association for Marriage and Family Therapy, which represents over 81,000 licensed marriage and family therapists, or MFTs, nationwide. This includes the over 1,800 MFTs licensed in Nevada. MFTs are mental health professionals trained in psychotherapy and family systems and licensed to diagnose and treat mental and emotional disorders. They place a unique emphasis on the role of relationships in our lives. As you know, Nevada has a dire mental health provider shortage. A 2024 Mental Health America report ranked Nevada 37th in the country for provider coverage, with a current rate of 420 residents to every one mental health provider. The impacts of access to care issues are even greater for those in historically underserved populations, including minority and rural communities. The issue of licensure portability is a viable and vital solution to meeting the various needs of Nevada residents. It is important that we remove unnecessary barriers to increasing access to critically needed and skilled marriage and family therapists. Assembly Bill 450 helps address the behavioral health workforce shortage in Nevada by removing unnecessary barriers to licensure by endorsement, which would encourage more experienced MFTs to work across state lines, either in person or through telehealth. This is essential to ensuring that Nevada residents have access to the mental health services they need, and is especially critical to people who live near state borders, families who reside across multiple states, or those who need very specialized care that only a small number of therapists provide. For example, multilingual therapists, therapists that are highly specialized in certain relational topics, or those who work with very young children. In 2025, AAMFT is supporting efforts in 10 states to remove barriers to licensure by endorsement. During the 2024 legislative session, bills to remove barriers to licensure by endorsement were passed in 7 states: Arizona, Georgia, Illinois, Iowa, Maryland, Tennessee, and Virginia. Licensure by endorsement currently exists in Nevada. However, the current statute continues to prevent some qualified providers from obtaining a license by endorsement. Additionally, the current statute gives the licensure board discretion to request additional unnecessary documentation from candidates. With Assembly Bill 450, we seek to streamline the process to open doors for more highly trained, licensed professionals to support the individuals, couples, and families in Nevada who are desperately in need of care. Under existing law, to obtain such a license by endorsement, an applicant must submit proof that they have not been disciplined or investigated by a corresponding regulatory authority in another state, territory, or District of Columbia in which they hold a license. AB 450 eliminates the requirement that an applicant submit proof to the board that the applicant has not been investigated, thereby making a person who has been investigated but who has not been disciplined eligible to obtain licensure by endorsement. Furthermore, as you will hear in a moment, we propose amending the bill to strike Section E, which requires applicants to provide, quote, any other information required by the board, unquote. Such permissive language allows the board to request any additional materials or documentation from candidates. The vagueness of the language can lead to significantly different interpretations of what information should be required, depending on who is sitting on the licensure board at any given time. Given that applicants for licensure by endorsement have already had all documentation verified by their initial state of licensure, we believe Section E is necessary and potentially burdensome for candidates. The reason it is possible for us to pursue licensure portability across the country is because MFT licensure standards are extremely similar across all 50 states. All states license MFTs. All MFTs are required to have at least a master's degree, and a number of them all have a PhD as well. There's an educational accrediting body called the Commission on Accreditation for Marriage and Family Therapy Education, or COAMFTE. Most states adopt the COAMFTE standards expressly by law, and the remainder adopt regionally accredited programs with very similar standards. All states also require that in order to be licensed, an individual must undergo multiple years of supervision, resulting in 3,000 hours of clinical supervised experience or its equivalent in direct client contact. The MFT profession places a premium on requiring specific hours of experience working directly with clients. And finally, all states require that in order to be licensed, an individual must pass the same National Marriage and Family Therapy licensing exam administered by the Association of Marital and Family Therapy Regulatory Boards. However, California has a state-administered exam that is considered as rigorous as the national exam. California is also currently in the process of transitioning to the national MFT exam, which would then have all 50 states taking the same exam. Additionally, under Assembly Bill 450, MFTs will still need to meet rigorous requirements to practice in Nevada when coming from another state. The applicant will need to have a license in good standing from another state, meaning no disciplinary acts related to competency, standard of care, or ethics violations. The Nevada board will retain the sole authority and responsibility for discipline related to clinical practice in Nevada, since this practitioner will hold a Nevada license. Recipients of licensure by endorsement will also be required to complete any continuing education requirements set by the Nevada Board. Finally, applicants will pay the full Nevada licensure fee, making this a no-cost measure for the state. In conclusion, the proposed legislation will increase access to quality mental health professionals in Nevada while protecting the high quality of care for residents that is provided by marriage and family therapists. Thank you to the committee for your time and consideration of this important piece of legislation, and I'll be happy to answer any questions.
Thank you so much. Are we having another presenter?
Bobby or not, for the record. Oh, sorry. Bobby or not, for the record, yes. Dr. Dominique Rice down south would like to speak as well.
Dr. Rice, when you're ready, please unmute yourself and begin.
Thank you. I appreciate it. Hi, Chair, Vice Chair, and members of the committee. My name is Dr. Dominique Rice, and I'm the founder and executive director of Hope, Love, and Dream Incorporated, a nonprofit organization committed to providing complex trauma-informed mental health services to individuals and families impacted by the justice system, child welfare, immigration, and the military. I've served in both direct service and executive leadership roles for the state of Ohio and state of Nevada across a wide range of systems, including community-based mental health, juvenile justice, adult corrections, state psychiatric facilities, and child welfare, serving individuals with severe mental illness, severe emotional disturbance, co-occurring disorders, and complex family and relational dynamics. As someone who personally navigated the licensure by endorsement process when relocating to Nevada from Ohio, I can speak firsthand to the challenges that exist even for seasoned professionals with years of experience and a clean disciplinary record. Despite being a licensed marriage and family therapist supervisor in multiple states and having served in high-level leadership roles, the requirement to demonstrate an absence of any investigation, regardless of outcome or merit, creates unnecessary barriers and delays, not just for me, but for the clients and communities I was eager to serve. My lived experience as a qualified provider trying to continue my work across the state lines is exactly why I support AB 450 and brings fairness, clarity, and efficiency to the process while still upholding the integrity of the profession and protecting the public. I'm speaking today to highlight the importance of not limiting licensure by endorsement solely because a provider has had a complaint or investigation filed in another state. As it stands, existing law under NRS 641A 242 requires that a marriage and family therapist or clinical professional counselor seeking licensure by endorsement in Nevada must provide proof that they have not been investigated under another licensing board. However, this approach does not distinguish between an investigation and disciplinary action, which are two very different matters. Let me be clear, I do support high ethical standards in our field and the importance of holding clinicians accountable. However, I also believe that a complaint, particularly one that is unfounded, under review, or administrative in nature, should not automatically disqualify a qualified or competent professional from practicing in Nevada. Many of us who serve diverse populations across the state lines are already navigating complex systems, and the update to AB 450 offers a necessary solution that allows for professional mobility without compromising patient safety. Licensure by endorsement is especially critical for ensuring continuity of care for mobile and underserved populations, including military families, tribal communities, and individuals impacted by the justice system populations I serve every day. In a time when mental health needs are skyrocketing and the shortage of providers are growing, we cannot afford to limit access to culturally competent and trauma-informed professionals who are committed to serving in multiple jurisdictions. We must evolve our licensure systems to reflect the realities of modern practice and the needs of our communities. Marriage and family therapists are uniquely trained to address relational, systemic, and generational trauma. Expanding our reach through reasonable endorsement pathways means more families get the help they need, when and where they need it. AB 450 corrects this by removing the requirement that applicants show proof they have not been investigated and instead focuses on whether the applicant has been disciplined by another board. This shift acknowledges that investigations are often procedural, may result in no findings, and not in themselves indicators of incompetence or misconduct. In a profession as human and interpersonal as ours, complaints can arise for many reasons, some valid, others not. Many investigations end with no action taken, and yet under current law, the mere existence of that investigation can prevent a qualified therapist from practicing in Nevada. This limitation does a disservice not only to the professional, it also harms our patient population, especially in a state facing a mental health provider shortage. Licensure by endorsement helps bring experienced, trauma-informed, and culturally competent providers to our state when access to care is more important than ever. It enables us to build a strong, flexible, and responsive behavioral health workforce that can meet the diverse and growing needs of our community. AB 450 strikes the right balance, protecting public safety while allowing for thoughtful and fair review of an applicant's history. I urge you to support this bill and join the effort to remove unnecessary barriers for professionals who are ready and able to serve Nevada's most vulnerable populations. Thank you for your time, your leadership, and your commitment to strengthening mental health services in our state. Happy to answer any questions.
Thank you for being here in your presentation. Chair Marzola?
Thank you, Vice Chair Elaine Marzola. For the record, Mr. Arnott is going to go through the bill and the amendment as well.
Bobby Arnott for the record. Going through the bill now, looking at page 2, section 1, subsection 2A2 on line 15. We are omitting or investigated from the list of disqualifiers for the licensure by endorsement process. As it stands in current statute, if an MFT wishes to utilize licensure by endorsement and has ever been investigated, they are disqualified. We want to ensure that folks that have been investigated and no wrongdoing was found or disciplinary action was taken, they can still qualify for licensure by endorsement. That's the bill as it stands, and as it is written right now. We have 2 amendments that we'd like to add as well. I can go over that now if you'd like.
If you would, Mr. Arnott, please.
So for the amendment, we want to make a couple additions to the bill. First, in section 1, sub 1, line 3, we want to change that the board may issue the license given that the applicant meets all the qualifications to shall issue the license. And second, looking at section 1, sub 2E, line 34, where the board can request any additional information of the applicant, we would like to strike that line out completely. Again, the purpose of the bill as currently written and the conceptual amendment is to strengthen MFT's ability to come practice in the state via licensure by endorsement while also maintaining fair and necessary qualifiers for such a process. We can stand now for any questions the committee may have.
Thank you so much. Committee members, any questions for Chair Marzola and her co-presenters? I will go to Assemblymember Hardy first.
Thank you, Chair, and thank you for this bill. So I just want to see if I'm getting this right. So if we're going to, according to the amendment, eliminate any other information required, and then if you go to number 3, then it says not later than 15 business days, they would have to request additional information. And then they would have 45 days once they get that additional information. So if they're not requesting any more information, I'm just trying to figure out, would it be, they'd have 15 days or 45 days to decide?
Bobby Arnott for the record. With the conceptual amendment, we might have to make some changes to that so there's parity in terms of the amount of days required, as one of those timelines is based off of additional information.
Members, any other questions? Okay, thank you for your presentation. Seeing none, we are going to go ahead and move into testimony. If you're here in support of Assembly Bill 450, please approach the witness table. We will start in Carson City, then we will move to Las Vegas, and then the telephone lines. Is there anyone in Carson City wishing to testify in support? Seeing none, we will move to Las Vegas. Please state your name for the record and begin when you are ready.
For the record, my name is Ashia, capital ASHIA, last name McReynolds, capital MC, capital REYNOLDS. I am a licensed marriage and family therapist, dually licensed as a clinical alcohol and drug counselor, and I am a supervisor in both. I am in support of AB 450.
Thank you for your testimony. Is there anyone else in Las Vegas? Seeing none, AVH, can we please check the telephone line for support for Assembly Bill 450?
Thank you, Vice Chair. If you would like to testify in support of Assembly Bill 450, please press *9 now to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will now move to opposition. Is there anyone in Carson City wishing to testify in opposition to Assembly Bill 450? Seeing none, is there anyone in Las Vegas wishing to testify in opposition? Seeing none, AVH, can we check the telephone line?
If you would like to testify in opposition to Assembly Bill 450, please press *9 now to join the queue. Again, if you would like to testify in opposition to Assembly Bill 450, please press *9 to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will now move to neutral. Is there anyone in Carson City wishing to testify in the neutral position on Assembly Bill 450? Seeing none, we will move to Las Vegas. Is there anyone in Las Vegas wishing to testify in the neutral position? Seeing none, AVH, can we check the telephone line?
If you would like to testify in neutral for Assembly Bill 450, please press *9 now to join the queue. There are no callers choosing to testify at this time.
Okay. With that, I will now close the hearing on Assembly Bill 450. Committee, we will stand in a recess.
Committee will come back to order. I will now open the hearing on Assembly Bill 332. This measure revises provisions relating to industrial insurance. I do want to let everyone know that I will be limiting testimony for the remainder of the bills. It will be 30 minutes for support, 30 minutes for opposition, and 30 minutes for neutral. 10 minutes here in Carson City, 10 minutes in Las Vegas, and 10 minutes over the phone lines. And with that, Assembly Member, you may begin when you're ready.
Thank you, Chair. I promise we won't use all 30 minutes.
Oh, no, you don't get 30, you get 15.
I'll go for 10 then. Thank you, Chair Marzullo and members of the committee. For the record, I am P.K. O'Neill representing Assembly District 40. I'm pleased to have the opportunity to present to you today Assembly Bill 332, which revises provisions related to industrial insurance. For a little background on this, subsequent injury funds began with a noble idea, providing state workers compensation funds to encourage the hiring of employees with disabilities, especially disabled veterans. These individuals may not otherwise be hired because of their perception that their pre-existing condition increases the risk of future medical and cash benefit payments. Subsequent injury funds were once nearly universal, starting in the early 1900s and expanded after World War II to cover nearly every state in the nation. These supplemental funds pay the portion of claims caused by pre-existing conditions. In Nevada, subsequent injury account was created to relieve a portion of the employer or insurer's claim costs when the employer hired or retained an employee with a pre-existing claim or medical condition who then suffered a second injury, thus creating a greater disability due to the combined effects of both claims or conditions. These subsequent injuries are compensated from an account or fund that is overseen by the appropriate subsequent injury board for the self-insured employers and the Division of Industrial Relations within the Department of Business and Industries. In recent years, there has been a national trend to abolish or phase out second injury funds. A recent legal article from the Thomas Reuters website noted that at least 20 states have either abolished or are phasing out of their funds due to the overlap with the Americans with Disability Acts or because of physical and administrative issues. This is a complex matter that requires balancing the interests of workers, employers, and the broader economy. Assembly Bill 332 aims to do just that. I would also like to introduce to you my, as we've said recently, call a friend, Richard Staub, who has been instrumental in helping me put this bill together and we'll be presenting with you today. Would you like to say anything?
Sure. Chairperson Marzola, members of the committee, thank you. My name is Richard Staub, and I am the interim CEO of Pro Group Management. Pro Group Management administers the 5 largest self-insured groups in the state of Nevada. We also insure more employees than any single self-insured employer or any public private insurer in the state of Nevada. We also are the largest insurer of employers and workers' comp in the state of Nevada. We're very proud of both of those levels of coverage. We have worked since 1994 in providing these types of associations with management, and I've been involved since that time as their general counsel. And of recent, upon the retirement of our CEO at Pro Group, I agreed to step in and take over some of the responsibilities of Pro Group Management. Assembly Bill 332 is somewhat of a house cleaning bill, but it has 2 provisions which we believe this committee should pay very close attention. If I might, members of the committee and Chairperson Marzola, I can go through the bill page by page very quickly if you would like. NRS 617 under Section 1, we're asking for a minor amendment to 616A060. This is a definition of an association administrator. In the state of Nevada, when you have an association of group self-insured employers, they can be private or public, we call them self-insured groups. They have to have a plan administrator or an association administrator. The association administrator is charged with managing the day-to-day insurance activities of the association of private self-insured employers. Each of these employers have to be in a similar industry, but they are private businessmen. They have to provide industrial insurance to their employees, but they're really not and have no expertise in managing an insurance entity, collecting assessments or premiums, rating, underwriting, safety programs, claims administration. They don't do any of that. Pro Group Management is an association administrator. We also employ rating organizations if we have to, actuaries. We have our own safety company, and we have a claims administrative company that we work with almost entirely. 6060 is a culmination of some discussions we've had with Commissioner of Insurance, and it specifically makes pro-group management and association administrators. There's only one other in the state, by the way. We have 5 groups. There's one public group and one small hospitality group. Other than that, pro-group management and its 5 groups are the largest. We insure thousands of employers and tens of thousands of employees. So we are what you could say the giant in the game, and that's why we're here. We added some language in subsection 1 regarding the fact that we work for a board of directors and we carry out the daily operations of the groups. We thought that needed to be clarified, and so we've added that clarification to 060. Going on to page 2, subsection 3 is an amendment to, or I'm sorry, subsection 2 is an amendment to 616B353. The interesting thing about groups is we are not only regulated by the insurance commissioner under Title 57, we are also regulated by the Department of Industrial Relations. So we have 2 administrative agencies that regulate us. Under this section, this is in 616B353, that is in the Industrial Insurance Act, and it requires bonding of not only plan administrators, but also third-party claims administrators. We're asking for an amendment to subsection 5, which specifically accepts the requirement of a third-party claims administrator to have bonding under 616B353, and to be required to have the same bonding under a 683A0857. 683A is in the insurance code. We litigated this case with the insurance commissioner and we won. And what happened years ago when the insurance commissioner, Commissioner Alice Mulaski Airman, was in charge, she recognized that 616B required bonding for the third-party claims administrator, and 683A required bonding for the third-party claims administrator. So she enacted a regulation, NAC 616B549, which allowed an offset of the bonding required in 683A0857 against the bonding that was required in 616B353. The unfortunate thing that's happened is our regulators have decided not to recognize that regulation anymore and have required us to provide bonding under both sections of the law, and we think that is not appropriate. And we have a hearings officer decision that agreed with us, but yet the commissioner's office required us to have double bonding. So we have a $100,000 bond under 683A, we have a $100,000 bond under 616B for the same reason, for fraudulent acts of the third-party claims administrator. We're asking for this committee to recommend due pass on eliminating that requirement, which existed for 20 years until the last 3 years. We're also asking for an amendment or section 3 of 616B371. This is a prohibition to allow Pro Group as an association administrator to have a financial interest in our claims administrative company. And this, we were requesting that that be deleted. Single self-insured employers can administer their claims. Private industrial insurers can administer their claims. In fact, most adjusting in large insurers is controlled within the company itself. With self-insured groups, we don't have that ability. We have to have a plan administrator that we contract and pay. We have to have a third-party claims administrator, which we have to contract with and pay. And that creates a disparity from a competitive standpoint, because we have to employ both and we cannot be involved in either. So we're asking for that requirement to be eliminated. If we want to open our own claims administration company, we could. And that's what 371's about. Going on, as PK pointed out, we're asking for association of self-insured groups to be allowed to not have to participate in the subsequent injury fund process. Now, we will be offering a conceptual amendment to this pursuant to the request of some of the stakeholders, which will take out single self-insureds and private carriers have asked to be removed from this requirement. Frankly, I don't know why. My clients don't know why, but we've agreed to allow that to occur, so we will be offering that amendment. The single self-insured groups that I represent still want to be allowed to be removed from the subsequent injury fund. We think we can do the same type of process within the four corners of our groups and not have to deal with the Department of Industrial Relations in this process. And the reason being is this. We pay an assessment into the subsequent injury fund for groups, for associations of single self-insured employers. We then make applications for employees that fall within the parameters of the subsequent injury account. So we're going back and we're asking for money we basically deposited with the Department of Industrial Relations. Then we file these applications. They take a long time to prepare. Then we have to go before a board of association of subsequent injury members, and we have to put on a case that allows us to get our money back. And sometimes these cases result in a denial, which we then must litigate in order to get money we paid into this fund. The first reason, and more importantly, these funds have turned into just cash pots. Even though the original intent was to insure people that had pre-existing conditions, that is not what these funds have. That's not how they operate. They operate merely as a place to go get money from, to reimburse the insurers for their insurance claims costs. And we don't think we should have to do that. We don't think we should have to ask for money that we deposited with the Department of Industrial Relations and then have to fight to get it back. And furthermore, we have 22 cases dating back to 2022 that are still pending before the Department of Industrial Relations. 22 cases. Between trying to man these boards, the board of Association Self-Insured Employers, and even the administrative staff, for one reason or another, there's always some glitch, and we cannot get our boards to meet and have quorums, and we can't get our applications approved or recommended for approval by the Division of Industrial Insurance Relations. So basically, we're asking the committee to recommend a do pass on allowing our groups to pull out of our subsequent injury fund, keep the money we pay them, and create our own ways to keep our employees working regardless of their disabilities. And with the advent of the ADA and HIPAA, we can't ask any questions about an employee's pre-existing conditions, yet that is one of the requirements for the subsequent injury fund. The requirement is that the employer have written knowledge of the pre-existing condition, a condition we can't even inquire about. And that makes it very difficult, which brings on the litigation. So we're graciously asking to be allowed to leave the subsequent injury process. The single self-insured employers and the privates have asked us whether we object to them leaving. If they want to stay in the subsequent injury process, more power to them. And the two other things is NRS 616B222. This is the hill to die for. This is a requirement in the state of Nevada which restricts an industrial insurer from collecting premiums. We collect premiums on payroll, the employer's payroll. That's how industrial insurers collect their premiums. It's based upon how much payroll they pay their employee. 616B222, which we're asking the committee to recommend a repeal of, caps that premium amount to $36,000. Now, we're all businessmen, we're all employers, employees. $36,000 isn't a lot of money. This bill has not been amended since 1995. it restricts an industrial insurer from collecting premiums on any payroll over $36,000. Now, I can tell you that my groups, my employers, their administrative staff make more than $36,000 a year. But the problem with it is we can't collect premium beyond $36,000. But if an employee is hurt and they make $100,000, my employers have to pay industrial benefits based upon $100,000. So we're asking to pay, to assume a liability that we are not collecting a premium for. And at the same time, with increased medical costs, increased settlements that we have to pay, industrial claims, which have gone up 30 to 40%. We used to pay permanent partial disability settlements, never really more than $50,000 or below. We're paying disability settlements now in the $100,000 to $200,000 range. This salary cap is inequitable, it's not workable, and it was enacted at a time when this state had the state industrial insurance system. We had a state fund. We don't have a state fund anymore. It's either single self-insureds, our groups, or privates. And we are unique to some extent in not having a state fund anymore. So we believe this has outlived its usefulness, and we're asking the committee to recommend to the legislature that this be removed. And briefly, the last section is 616P 410. These are annual audits that we have to conduct on our members who report payroll to us. This is a statute that requires an audit based upon standard industrial classifications. None of my clients rate their employees based upon standard industrial classifications. The state industrial insurance did it 20 years ago. We don't use standard industrial classifications now. We have our own classification structure that between our rating people and our underwriting people and our actuaries, we've developed on our own. It's been approved by the insurance commissioner. They know exactly what we're doing. We do audit our members based upon the payroll report they report, but we don't do it based upon standard industrial classifications. And so we're asking for the repeal of 616B 410 because it's old, it's not used anymore. We don't audit based upon SIC codes, standard industrial classification codes. And the problem is that the commissioner's office has said, well, look, 616B 410 requires us to audit based upon these SIC codes, so that's what we're going to do. And so that's why we're asking for it to be repealed. We don't collect our premiums based upon standard industrial classifications. There's absolutely no use for 410 any further in the industrial insurance system. And that's my presentation, Chairperson Mazzola and members of the committee, and I'll stand for questions.
Chair, may I add, P.K. O'Neill for the record. There is a physical note attached from the Division of Industrial Relations. I have received a notification from them with the amendment that has been put up on Nellis that their note will be going away. As was said, we'll stand for questions. Thank you.
Thank you for your presentation. Committee members, are there any questions? Assemblymember Anderson?
Thank you, Chair, and thank you for the presentation. I was getting a little bit lost there, not just because of the Amber Alert, but also because of a few other things. So you brought up the hearing officer statement, that there was some sort of discussion around a possible difference of opinion. So first of all, can you tell me what section that's actually dealing with in either the bill or the amendment? But then second of all, it feels like, and I think it's important you know it just feels like this, it feels like we're being asked to make a possible change to something that's actually right now still being discussed. So I just need that clarification as to what exactly the situation is that you brought up.
Thank you, Richard Stahl, for the record. Assemblymember Anderson, if you're talking about the subsequent injury fund, when we identify that an employee has a pre-existing condition and has another injury, we have the ability to go to the subsequent injury fund to receive money back from that fund. We have to file an application. The application is reviewed by the Division of Industrial Relations. The Division of Industrial Relations provides a yay or nay that they recommend approval of the application, wherein we'll get a disbursement of money out of the subsequent injury fund, or they can recommend a denial of the application. If it's for whatever reason, recommend or deny, we go before a board of Association of Single Self-Insured Employers, employers who are members of the self-insured groups. There's 5 of them, and they're appointed by the governor, and we have to go either agree with the division's recommendations or disagree with the division's denial. And we have to put testimony on to show that we meet the requirements of the subsequent injury statute. One of the requirements of the subsequent injury statute is that we have to show that our employers have written knowledge of the pre-existing condition. And we have to show that they have a certain level of impairment, 6%, and we meet this criteria, we argue it out, and the board either approves the recommendation to pay on the application or to affirm the denial of our application, and then we get nothing. But interestingly, of all the applications that we file in a year, at the end of the year, if there's any money left in the group self-insured association SIA fund, it's paid back to all the groups that paid in. So it's kind of a complex situation, and we'd like to just get out of it because we just like to keep up the money and do our own loss control on helping people stay employed that have pre-existing conditions. We think we can do it, and we don't have to have 22 applications sitting in lingo. We don't have to litigate getting the money, and so it's just, I think it makes a more efficient process to just let the groups make their own loss control decisions. And added to that, we don't have the ability to ask about people's pre-existing conditions under HIPAA.
Okay, so thank you. So just straight to the point then.
Sure.
Number one, is there a hearing currently in process that this is going to be changing that's happening right now? That if we were to if this language were to get through, would this impact a hearing that possibly is in front of the group right now?
No.
Thank you. Second question, again, really quick, straight to the point.
Sure.
Where is this change? What section in the law is this coming from of the proposed language that you're looking for in AB 332? And don't forget to say your name too.
Specifically, it's NRF 616B.
Can you please state your name for the record?
One second. I'm Richard Staub for the record. I'm sorry. It starts off on Section 4, NR 616B 554, but 554 and 557, 560 only have to do with single self-insured employers. The crux of the matter is Section 8, 616B 578. That's the hill to die for right there.
Thank you so much, and thank you, Chair.
I'm sorry if I was lengthy.
Just to piggyback on my client, the assembly member's question, just so I can wrap my head around it. I am not a work comp attorney, so you're asking that these specific groups do their own, control their own losses, right, that are being claimed? Do I understand that correctly?
Richard Staub for the record, yes.
Okay, so taking out the third-party administrator out of the equation, correct?
We would have to work through the third-party claims administrator to actually, they are the ones that process these subsequent injury account applications for our groups.
Okay, so in section 4, page 6, you're wanting to take out section 4, subsection 1. Yeah, and subsection 2. So can you explain the two sections? Because I think that's maybe where some of the confusion is. It seems like you guys want to be able to open your own claims. You're wanting to be the claims administrator as well when a claim is open. Do I have that correct or no?
Richard Staub for the record. That is correct. We want the ability, if we wanted to, administer our claims as pro group without having to employ a third-party claims administrator.
Would that create any sort of conflict?
Well, the implication when the group self-insured laws were enacted was, yes, it would be a conflict. The problem is when you look at the way industrial insurance, or really any insurance in the state operate, private carriers have been adjusting their own claims since inception. In other words, if you wreck your car, you get in an automobile accident, and you're insured by State Farm Insurance, you're going to be talking to a State Farm adjuster who's employed by State Farm. We don't have that ability. We have to hire ABC Claims Administration Company and pay tens of thousands of dollars in fees to them to administer our claims. We have to compete with private industrial carriers. So we would like parity. If we want to self-administer our claims like single self-insured employers can, we want that ability. Or at least potentially to maybe have a financial interest in the company that does our claims. We do not have that ability. And if there's a conflict there, then there's a conflict with private industrial carriers self-adjusting their own claims, which has been going on since the inception of casualty insurance.
I probably have a lot more questions, but let me go to my committee members. Okay. Committee members, any additional questions? Assembly member, sorry, I'm still trying to wrap my head around what you said. Assembly member Carter.
Thank you. I was grabbing onto something that was mentioned during your presentation, that you pay claims on up to, you mentioned the $100,000 number, but isn't it true that in the state of Nevada that it's capped on the maximum compensation that you're paying out is based on about $85,000, nowhere near the $100,000 number that you quoted?
Richard Staub for the record. There is a state maximum wage rate, and it's about $8,000. So somebody could be making $100,000. They only get paid 66 2/3 of their wages up to the max, and that max is adjusted. So I apologize, my example may have been at $100,000, but there is a cap on the max amount of money that we will pay an injured employee during his disability as a result of an industrial accident.
Assemblymember Yurick.
Thank you, Chair, and thanks for the presentation and for taking our questions. Your analogy with private insurance carriers administering their own claims and a workers' compensation carrier having to use a TPA, and maybe you can help me clarify, but I understand that there is, for private insurance carriers, if they were to administer their policies in bad faith, there's a separate cause of action that could be brought against a carrier that was administering their policy in bad faith. I didn't think there was, or can you clarify, is there that same remedy for folks to bring a separate bad faith claim in the workers' compensation context?
Richard Staub for the record. Assemblymember Yurick, there is no prohibition. I can tell you, as far as I know, I've never seen a bad faith action against a workers' comp claims administrator. NRS 616D is what they call a benefit penalty and punitive section of the Industrial Insurance Act, and claimants who have been injured by the improprieties of a claims administrator can ask for benefit penalties, and the Division of Industrial Relations will investigate them and could administer or assess fines against the claims administrator. But there is no prohibition from a injured employee from bringing a bad faith action against a third-party claims administrator. I'm not aware that it's ever happened.
Assemblymember Cole, did you have a question?
Thank you, Chair. Thank you for the presentation. This is admittedly complex territory, right? So I actually did reach out to my insurance broker to try to get some clarity on how things work as relates to the 616B 222 Hill to Die For. So my question is, the cap right now stands at $36,000, and that's across the board. Doesn't matter what kind of job you do, whether you are a secretary or you are a truck driver or you are working in a, heavy excavation kind of job, correct?
For the record, Richard Staub, that's correct.
Okay, but the way in which, as I understand it, at least private insurers, the way that they adjust their premiums and do their underwriting is based on what you called the standard industrial classification. So there's different multiplier if you are a heavy equipment operator versus a secretary, and that's how they actually come up with the premiums. Is that correct?
For the record, Richard Staub, that is correct, but they still only can collect their underwriting can only be based upon $36,000 in payroll.
Right, but 36,000 times 1 is different than 36,000 times 5, if that's the number. And I'm probably not giving a real good example on that, but I guess my question is, and this is directly tied to the Division of Insurance's statement in the record that they're not real comfortable with just eliminating it and instead doing something that adjusts the cap. And maybe it's an adjustment, it's not 36,000 anymore, maybe it's 50,000, whatever that number is. Or maybe it's based on classifications of job type. And I don't know the answer to that, but I'm thinking that might be an easier way to approach the problem. And I don't know if that was a question, but do you think that could be an easier way to approach the problem?
I was just going to, Richard Staub, for the record, I was going to say, is there a question? Do you want me to answer the question? Yes. The commissioner had an omnibus bill before this session, and he said the payroll cap repeal was in that bill.
Committee members, any additional questions? I don't see any. So we will move to testimony in support of Assembly Bill 332. Is there anyone here in Carson City wishing to testify in support? Please remember to state and spell your name for the record.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Andrew McKay, A-N-D-R-E-W, M-A-C-K-A-Y. I'm the Executive Director of the Nevada Franchise Auto Dealers Association. I don't think I've ever actually put it on the record in this committee. Our trade association represents all of the new car, light truck, and heavy-duty truck dealers across the state of Nevada. I'm here in support of AB 332. Obviously, you guys have a full agenda and are pinched for time, so I'll keep my remarks as brief as possible, and hopefully I don't even run into the 2-minute cap. We are a sponsoring organization of a self-insured group. The Nevada Auto Network Self-Insured Group specifically is the name. Want to thank Assemblyman O'Neill as well as Richard Staub for the work that they have done on this measure. I want to hit really on two specific issues which were the majority of the questions from the committee. First, with the subsequent injury fund. I'm actually on that board. I'm one of the 5 gubernatorial appointees. While DIR does a stellar job organizing those meetings, I think an easy way to describe it is perhaps a bureaucratic quagmire in the fact that they have to spend an inordinate amount of time preparing the agendas, the exhibits, et cetera, whereas they could avoid a lot of that, and there are substantial costs associated with that as well, up to and including representation from the Nevada Attorney General's office. But I do want to put it on the record and give a shout out to DIR that they do a stellar job, but it takes a lot of staff time for them to organize it. With respect to the payroll cap, I think the representations that is priority one of the bill, we would echo those. And it's really simply this. It allows businesses to be able to manage their cash flow a lot more effectively. When you look in terms of the franchise auto dealers, I'm time up. Can I have 10 seconds, Madam Chair?
10 seconds to finalize.
I'll
Ready,
be
go.
quick. The average wage that we pay is $98,000 a year approximately. So we hit that cap at approximately midpoint of April 1. So it will enable my dealer members to be able to manage their cash flow a lot better. So Madam Chair, thanks for the additional time, and thanks to the committee.
Thank you. Is there anyone else wishing to testify in opposition? I don't see any. Is there, oh, sorry, support. Is there anyone wishing to testify in support in Carson City? Is there anyone wishing to testify in support in Las Vegas? I don't see anyone. Broadcast, is there anyone on the line?
Thank you, Chair. If you would like to testify in support of Assembly Bill 332, please press star 9 to join the queue. Chair, there are no callers choosing to provide testimony at this time.
Thank you. Is there anyone in Carson City wishing to testify in opposition to Assembly Bill 332? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition? Don't see anyone walking up. Broadcast, is there anyone on the line?
If you would like to testify in opposition to Assembly Bill 332, please press star 9 to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? Please remember to state and spell your name for the record.
Thank you, Madam Chair, members of the committee. Adam Plain, P-L-A-I-N, with the Nevada Division of Insurance, testifying neutral today as a matter of policy. I want to thank you for reading the written testimony that we submitted. It's always appreciated, or it's nice to know that it's being read. Wanted to clarify a couple items related to the payroll cap. To begin with, the division had a bill that we sponsored this session, Assembly Bill 74. Payroll cap provisions were not in Assembly Bill 74. Just clarifying that. Additionally, regarding the concern that we expressed in our written testimony, wanted to note that for fully insured and self-insured groups, we have rate service organizations that provide those multipliers for the wage. Those are done by a group called NCCI. I remember what the acronym stands for. The National Commercial Compensation Insurance Council or something. I apologize. NCCI sets their multipliers one time per year. So our concern that we expressed is just that a straight repeal without giving NCCI time to phase in changes as a result of the repeal might cause some short-term instability. And so our ask is that if the committee and the bill proceeds, that maybe the effective date be staggered or set so that NCCI has enough time to readjust those factors and doesn't cause that short-term instability. And I'd be happy to answer any questions.
Thank you for your testimony. I don't believe we have any questions. Thank you. Is there anyone else in Carson City wishing to testify in neutral? I don't see anyone. I see that you are seated and ready. You may begin.
Good afternoon, Madam Chair, members of the committee. Victoria Carrion for the record, Victoria. Last name is spelled Carreon. I'm the administrator of the Division of Industrial Relations. We are responsible for administering the subsequent injury accounts that you have heard about. We also run the board meetings as well. For the subsequent injury account for self-insured employers, we only have 2 pending matters that are waiting for a board meeting, and we have 8 cases that are pending review. I'm not really sure where the number of 22 came from. There was a extended period of time where we did not have a quorum of board members appointed by the governor. And so there was a backlog of cases that could not be considered because we didn't have a board to hear them. So that might have been when there was a larger number, but it is a much more limited number, and we do thank the board members for their service. In terms of the impact of the amendment, we'd like to take a little bit more opportunity to review it and make sure we understand the impact of it. As I read it, it does look like it continues the assessments even for the self-insured employers, associations of self-insured employers. And so we'd just like to understand a little bit more about the impact of it, because it does appear that we would still have jurisdiction over certain subsequent injury claims that were incurred before September 30th of 2025. Thank you.
Thank you for your testimony and providing that additional information. I really appreciate it. Is there anyone else in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
If you would like to testify in neutral for Assembly Bill 332, please press star 9 now to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. Assemblymember, would you like to give any final remarks?
Thank you, Chair. I'll make this very quick. Thank you and the committee members for the presentation today and your interest in this. As was basically stated at the beginning, most of this is a cleanup bill. Just as businesses and practices change, modernize over time in the years, so is the need for workers' comps to update itself in its practices. That is exactly what AB 332 is doing today. Thank you all very much for your time, and I would appreciate your support on the bill.
Thank you. I will now close the hearing on Assembly Bill 332. I will now open the hearing on Assembly Bill 376. This measure makes revisions relating to insurance.
You can tell insurance is my expertise.
You may begin when you're ready.
Thank you, Chair. Thank you, Chair Marzola and members of the committee. For the record, once again, I'm P.K. O'Neill, representing Assembly District 40. I'm here to present Assembly Bill 376, which is revising provisions relating to insurance. With me today are the Nevada Division of Insurance Commissioner Scott Kipper and his assistant Adam Plain, Insurance Regulations Liaison with the Division of Insurance. For some background, I am pleased to bring forth AB 376 today to address an urgent and an important matter facing many homeowners in my district, statewide, and actually nationwide. And that is the issue of homeowners insurance. As you are aware, many housing developments within Nevada sit squarely within the wildland-urban interface, which is just a fancy way of saying they're in the transitional space between forest and developed land. Due to the many factors, not the least of which is the risk of wildfire, many Nevadans are facing the cancellation of their homeowners insurance policies. Others are trying to purchase homes and cannot close the deal, as they cannot find an insurance company willing to underwrite their homeowners policies. This is an issue not unique to Nevada and is indeed a nationwide challenge. And working with the representatives from the Division of Insurance and the insurance industry, we are offering an amendment to AB 376 to address the issues of homeowners and insurance availability. The amendment is patterned after modeled language used in other states and the National Council of Insurance Legislators, known as NCOIL, NACOA. The amendment does 4 things, which I will summarize and then turn over to Mr. Plain to go through the detailed walkthrough of the bill itself. Sections 7 through 20 create a 4-year program for insurers to experiment with insurance products to meet the needs of homeowners and industries to cover customers that are having difficulty filing insurance. The primary goal of the experimentation program is to foster innovation in the insurance industry by creating a safe space for testing new products or services that might not fully comply with current regulations. The experimentation program will demonstrate to industries Nevada's willingness to consider their needs and attract new and emerging businesses. At the end of the 4 years, the Commission of Insurance would provide a report to the legislature about the operation and results of the program for us to take further action, if we so desire. Section 20.1 would establish a mechanism for flexible insurance rate changes depending upon market conditions. The insurance commissioner would set the threshold for the maximum annual rate change after public hearings and input. Section 25.1 would allow insurers to include wildlife or wildfire coverage from a standard homeowner's insurance policy and instead to create a standalone insurance product specifically for wildfire coverage. This is not unlike what the current existing is for flood insurance. Section 25.3 would allow homeowner associations to become captive insurers, combining their resources to cover the assets of those in their association. Now I would like to turn it over to Mr. Plain for a detailed walkthrough of the amendment and bill.
Thank you, Assemblymember O'Neill. Madam Chair, members of the committee, for the record, Adam Plain, P-L-A-I-N, Insurance Regulation Liaison with the Nevada Division of Insurance. As Assemblymember O'Neill mentioned, sections 2 through 20 of the bill propose to add new language to Chapter 679B, authorizing a sandbox innovation program for insurance policies covering property risks. Sections 3 through 8 add necessary definitions for the implementation of the sandbox program. The proposed amendment would delete Section 4, as references to the Director of the Department of Business and Industry would no longer be necessary, and Section 7 would be amended to clarify that the program applies to both real and personal property, and to remove the minimum policy value to participate in the program. Section 9 authorizes the creation of the sandbox program and would be amended to clarify that real and personal property policies are eligible. Section 10 provides the commissioner explicit authority to adopt regulations should they be necessary to flesh out the sandbox program, and the proposed regulation would remove some duplicative language. Section 11 outlines the disclosures that must be provided to consumers when they are presented with a policy authorized by the Sandbox Innovation Program. Section 12 requires an insurer wishing to participate in the program to submit an application to the commissioner for the specific innovative product the insurer wants to bring to the market. The list of requirements for the application are proposed to be amended to stipulate that an insurer wishing to apply must offer at least one other real or personal property product in the state, must list specific statutes or regulations they wish to waive to test the innovative product and justify the need for such waivers, and target their application, at least in part, to underserved or high-risk areas of the state. Section 13 permits the commissioner to request additional information on any submitted application. If the applicant fails to provide the necessary information, the commissioner may refuse to consider the application further. Once the application is complete, the commissioner shall render a decision within 90 days. Section 14 provides a general timeline for the commissioner to communicate approval or disapproval of an insurer's application. The proposed amendment would eliminate language in sections 14, 16, 19, and 20 relating to the Director of the Department of Business and Industry. Relevant appeals and hearing language already appears in Chapter 679B, and the process does not need to be duplicated with the Director's Office, which really is not equipped to handle potential appeals. Section 15 lays out the process for approval of an application. The amendment clarifies that an approved application is only exempt from the statutes and regulations specifically mentioned and justified in the application. The commissioner may approve an application on the condition that the product is not exempt from one or more of the statutes and regulations specifically mentioned in the application, and an approved product is limited to an initial trial period not to exceed 36 months, with one extension not to exceed an additional 12 months. Sections 16 and 17 reiterate the Commissioner's authority to review records with language specific to the Sandbox program. Section 18 requires the Commissioner to report on the results of the Sandbox Innovation Program to the Legislature after a period of 3 years have passed. The proposed amendment would eliminate the broadly worded economic and actuarial analysis required under the original language in order to keep the program cost-effective. The amendment also harmonizes the division's role in providing data for the legislative body to digest without editorializing that data. Section 19 provides explicit authority for the Commissioner to remove a participant from the program if the participant violates the terms of the program. Section 20 reiterates the Commissioner's existing authority to act to protect consumers. This seeks to prevent disagreements about how existing regulatory authority extends to the Sandbox program. Sections 21 through 25 originally proposed to change Nevada's prior approval process for all regulated lines of insurance except health insurance to a use and file program. These changes are proposed to be deleted by the amendment and replaced with Section 20.1, which would create a flex rating system specific to policies covering real property. The flex rating system would permit the Commissioner to annually hold a hearing to determine a threshold rate change based on current economic and market conditions. Any rate change within the threshold would be automatically approved if it meets certain criteria. The program of flex rating is intended to ease regulatory burdens for insurers needing to raise rates on real property policies to meet changing conditions, while still limiting those automatic increases both by the magnitude of the change and the frequency with which they may occur. The amendment proposes to add a new Section 25.1, which would explicitly permit insurers to offer policies that exclude the peril of wildfire or only cover the peril of wildfire. This would be similar to current earthquake exclusions and coverages. Section 25.1 also proposes a basic definition of a wildfire, but allows insurers to propose their own definition subject to regulatory approval. Newly proposed Sections 25.2 and 25.3 would permit individual homeowners and groups of homeowners or common interest communities to insure their properties by means of captive insurers. Captive insurance would operate similar to self-insurance, except that the division would have regulatory oversight of the captive. For persons who are unable to secure other coverage or who have the means and desire to self-insure, a captive may be a viable option. Section 25.4 proposes to repeal a requirement that common interest community unit owners associations provide insurance on the individual units within the community if there are shared horizontal or vertical walls. This change is intended to permit individual unit owners to insure their units separately, thus spreading the risk of potential loss in a single community across multiple insurers. Finally, Section 27 provides that the Sandbox Innovation Program and the ability to exclude the wildfire peril would go live on January 1, 2026, and explicitly expire on January 1, 2030, unless reauthorized by the legislature prior to that date. The provisions regarding captive insurance and common interest communities would go live July 1, 2025, and do not expire. And I realized too late that the amendment does not actually contain a reference for the flex rating program effective date. That program is intended to follow the provisions for captive insurance and common interest communities, going live on July 1, 2025 on a permanent basis. Assemblymember?
Thank you. For the record, P.K. O'Neill. Chair, with your permission, I'd like Commissioner Kipper to give a brief statement about some of the challenges the state has faced and how the citizens are looking for answers.
Good afternoon, Chair Mazzola. For the record, Scott Kipper. That's S-C-O-T-T. Last name is Kipper, K-I-P-P-E-R, Nevada Insurance Commissioner. And pleased to be here today. Really appreciate working closely with the Assembly member on my right in the development of these amendments. We feel that these are fair, as we work to create a fair regulatory environment. Last summer, the division had held a number of town hall meetings. One was in Incline Village, another one was in the Arrow Creek area of Reno. And we listened and heard loud and clear of the challenges that Nevada consumers were having in attaining homeowners or condominium owners coverage. Under the current Nevada statutes, there at that time, very little that could be done to require carriers to insure different risks. We believe that these amendments provide ample incentive for insurers to fully participate in not only getting innovative products to the marketplace, but also giving them a little bit more, excuse me, the term flexibility in order to generate revenue that they tell us is needed in order to manage the risk. There's really only two ways that insurance companies can manage that risk. That is through generating additional revenue or eliminating some of the areas of risk, which we've seen in non-renewals or policy terminations. So we believe that this is a great step forward to assist those consumers. And with that, Madam Chair, we'd stand for any questions you might have.
And Chair, may I add P.K. O'Neill for the record. I may get a little too granular here, but this is just not a northern problem. Actually, down south, for those of you from the Las Vegas, Clark County area, you've got the same issues occurring up in Mount Charleston area with homes there. One of the things that I learned from these town halls attending them is one of you may have a house that has defensible space, you've got a metal roof, et cetera, and of taking every precaution in the world from wildland fires. Your neighbor, unfortunately, thinks it's whatever you may say, a bit of a joke, has not taken any activities. The insurance companies not only look at your home, but they will also look at the neighborhood in general to see what that does to the increased possibility of fire and the added damage. And that's what a lot of them were facing. And we, at the discussions by the limited statutes currently in effect, we're not able to really have a, for lack of a better term, a good answer for the homeowners, both here and down south. That's why we got together, and I appreciate the insurance commissioners and his staff and others, the industry, for coming forward and working together, saying, this is what we could do, we couldn't do. We are modeling some of, as we said, after other states and professional organizations. So with that, we are ready for questions. Thank you, Chair.
Thank you for your presentation. We will start with Vice Chair Howdigi.
Thank you, Madam Chair. And I was reading through this bill, and I immediately recognized that it was an insurance regulatory sandbox. I was here in 2019 when we passed our first sandbox. It was a fintech sandbox under the Department of Business and Industry, and I think they're great. And that was my first assumption, too, reading through the bill. Like, this has to be to address wildfires and the lack of insurance available for homeowners in certain areas. And so I just started doing some research, and I realized that most of the states, there's not that many states who have passed insurance regulatory sandboxes, but none of them that experience like wildfires have. So can you talk to me a little bit about some of the other states, if you have the information, and how the insurance sandboxes have worked in other states? And can you give me an example? I mean, I guess you did. You gave like an HOA becoming a captive insurer. That could be one innovative insurance program. But like, do you envision this more? I think of immediately Northern Nevada and the general improvement districts, right? So I think one of the most famous ones, like having Incline Village just become their own captive insurer. Is that how you envision it working? And can you talk to me about how this has been successful for homeowners insurance policies or other types of insurance policies in the other states who have passed it?
For the record, Scott Kipper and Vice Chair Howdigi, thank you for the question. Regulatory sandboxes, as far as homeowners goes across the country, really has not really taken flight yet. There's a number of challenges in that area. what we've seen in some states that have an insurance regulatory sandbox is the development of a couple things. One is innovative policy design, not a standard homeowners policy, but variations on that theme. One of the other types of entities that have attempted to take advantage of an opportunity in sandboxes are those insurance carriers that have may not have the level of the solvency requirements, but want to test those waters nonetheless. And so those are the two areas that we have seen. I reference primarily the state of Kentucky. We had spoke with in great detail on this issue, and that has been their experience when it comes to their sandbox.
Yeah, it was my understanding that Kentucky was the first state to implement the insurance regulatory sandboxes. Can you talk to me a little about what this is going to do for cost, like insurance premiums? Now, I know, I mean, having insurance coverage is better than not having it at all, but do you envision this actually being like priced moderately, or do you envision these being expensive policies for homeowners?
For the record, Scott Kipper. I think when it comes to pricing, I think we're still going to it'll be expensive. I guess in short order, it's still going to be expensive because of the level of risk and the potential risk. Certainly the LA County fires have shown us that the potential for wildfire can happen almost anywhere in the West. And insurance companies are well aware of that risk and are managing that risk by the level of premiums in which they now will apply to in states that have prior approval or implement in those states that have a file and use type of program. But I think in the short run, until the marketplace moderates, we're going to be looking at as much more expense as there is. I will say in defense of the state of Nevada, we have enjoyed some of the lowest homeowners rates in the West for a very long time, and the state has been a fairly profitable place for those homeowner companies to operate. But I think they're becoming more and more aware of the increasing challenge and risk in the state.
Thank you. This is my last question. I know that like in our homeowners insurance premiums here in the state, I think they're like 33% lower than the national average. If you can get homeowners insurance, unfortunately, there's the areas where you can't because of the higher risk of wildfires. But and so just my last comment was, I know that our homeowners insurance premiums are lower than other states. Unfortunately, our car insurance premiums are higher, and we have some of the highest. And so if this is successful in homeowners insurance, you know, I think the average homeowners insurance premium in Nevada was about $1,300. The average car insurance premium in Nevada is about $2,000 a year. And so I would really love to see this expanded to not just homeowners insurance, but automobile insurance too, if it's successful. Thank you, Madam Chair.
Next, we'll go to Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. Please bear with me. This is all new to me. But I guess I kind of see this bill in two parts. So I see that there's one, the sandbox provision, and then separately, there's an actual implementation of some of the things the sandbox may ultimately recommend. Is that correct? Is that a fair assessment?
For the record, Adam Plain, Assemblymember Roth. That's a fairly good assessment. Some of those implementation items that you mentioned are things that could have theoretically been contained within a sandbox program. We're explicitly laying them out in this proposal because we thought that they deserved extra attention.
And so based on that, is there a reason that we're not, I guess, have other states who've done the sandbox, have they walked back any of those provisions that we want to put in statute? And is there a reason that we're not starting with the first part?
For the record, Adam Plain. As Commissioner Kipper mentioned earlier, the sandbox implementation on a national scale in the insurance space is fairly young. There are a very small handful of states that have tried this in the insurance space. Take-up has not been quite high yet. And so I think part of the impetus here is to spell out specific things that we're looking for as a state to spur and encourage participation in the sandbox program. But we're leaving it open so that insurers have the ability to craft whatever ideas they are able to come up with, essentially.
Assemblymember Cole.
Thank you, Chair. So my question has to do, following up on a colleague's question, on the pricing, right? Like, we understand that the fire, I'm very happy that they'll be able to get fire insurance, right? I think that satisfies the mortgage question and all of those things, but the cost, I think you're right, it's going to be very high. So I know that there have been some recent changes in regulations over the last few years when it comes to defense within limits policies. So I'm just wondering if maybe one way to try to lower the cost for this type of insurance would be to actually carve them out so that they are able to issue policies of defense within limits, if that makes sense. So what are your thoughts there?
For the record, Scott Kipper, and thank you for the question, Assemblymember Cole. Certainly that is the prerogative of the legislature to address it. I think anytime we're talking about issues such as that, I think there's opportunity for innovation and creativity. And I think that there may be an opportunity for some consumer savings.
Assemblymember Carter.
Thank you. This is going to be difficult. In regards to wildfire coverage, we've seen how that climate change is drastically affecting the insurance industry. And it's likely, with the lunacy going on in DC for the next 4 years, to get worse. And I've seen it to where we're dealing now in my district with people's houses being flooded that are nowhere near a flood zone, so they never had flood coverage. And it sounds like you're proposing to move wildfire coverage out of a understood piece of homeowner coverage to an a la carte item similar to flood insurance, but I don't believe, is that what's being proposed? And is there any federal safety net like the National Flood Insurance Program when it comes to wildfires? Or are we just going to turn everybody loose and let the fires burn their houses down?
For the record, Scott Kipper and Assemblymember Carter, thank you for the question. First of all, the provision there is that writing standalone wildfire insurance would be an option for carriers. They could keep it in their standard homeowners list of perils, or they could write their own or carve it out. That would be an option for carriers. And the reason that we would consider having them opt out is to take that basic package of perils and make that an affordable package for consumers, as opposed to including a wildfire peril and pricing it accordingly. And as far as your question about the NFIP and the national program, and is there a national safety net, there are certainly a number of considerations taking place in Congress right now that would provide either a national wildfire peril insurance program or some sort of reinsurance safety net that states could apply to and be reimbursed in the event of a catastrophic fire.
Thank you.
Assemblymember Anderson.
Thank you. I had a similar question as the opt-in when it came to the wildfire, but now I've got a second question. So thank you so much, Chair. When I take a look at what you're talking about in the amendment under Section 15, where the qualified insurance product is eligible for only no more than one extension, because it's something new. But then when you take a look at Section 13.2 of the bill, it's on the top of page 6, where you allow for a mutual agreement to extend a period. Why is that also not a possibility of being able to allow for a mutual agreement to be able to extend for possibly a longer period if needed? Or if that is something that could possibly be considered for the future?
For the record, Scott Kipper, and thank you, Assemblymember Anderson, for that question. I think that certainly the division would be flexible enough to consider those applications, whereas the statutory language would be limiting. We wouldn't have no problem if that was loosened up and allowed for further consideration.
For the record, Adam Plain, Assemblymember Anderson, two quick notes. First note, Section 13 is dealing with the application process to enter the program. So the mutual agreement to extend is to extend the period in which the commissioner has to review the application to determine whether it's eligible. It's not the actual effectiveness or effective dates of the application if approved. And then the second quick point I wanted to make was that because the provisions for the Sandbox Innovation Program would expire exclusively in 2030, an initial 36-month term plus a 12-month extension would take us straight to that expiration date.
Assemblymember Torres Fawcett.
Thank you, Chair, and thank you for the presentation. I definitely have been kind of following along with some of the issues that we've been having for homeowners across the state. I'm just wondering what we would do if one of the tests insurance products failed or it's discontinued. How will we ensure that we are protecting the consumers?
For the record, Scott Kipper, and thank you for the question, Assemblymember. As part of the application, carriers would have to lay out their plan in the event there was a failure as you laid out. So it'd be up to the carriers, and that would be in the application process as to what they would do in the event that the policy failed.
Thank you, and just a quick follow-up. And so would there be any recourse for the consumers if they do experience some type of harm after they have received or not received the product?
For the record, Scott Kipper, and I think the recourse that consumers would have now would simply follow, or that consumers would simply follow the recourse that they currently have under the insurance code, that the division would be able to step in and advocate for them through the complaint process. If the division felt that there was something beyond that we needed to investigate and pursue, we have the authority to do that as well.
Committee members, any additional questions? Assemblymember Urick.
Thank you, Chair. And boy, I appreciate creative solutions to very real challenges, and I see this as a pretty unique opportunity for us. And I also appreciate the sunset provision so we can give this a thorough testing period to see how it works out. And so I imagine we're looking for the availability of coverage at affordable rates would be some metrics, but have you considered, can you give us an idea of the type of performance metrics or outcomes that you might be considering as we get to the end of this to see if it actually improved the insurance market in these affected areas and whether or not this is something we would want to continue? Can you just kind of give me an idea what you're thinking there?
For the record, Scott Kipper, Assemblymember Urick. The division currently goes through a data call, has for each of the last 3 years, year ending 2022, 23, and 24. And we look at those numbers as far as the number of policyholders who have been terminated or non-renewed. I think that would be certainly a metric that we are very, very much honed in on. One of the things that we would like to look at is to see if the effectiveness for individual companies is if they're continuing to write the same market share within reason, or have they stepped away, particularly for those companies that are taking advantage of Sandbox Innovation Program.
Committee members, any additional questions? I don't see any. So we will move to testimony in support. Is there anyone here in Carson City wishing to testify in support to Assembly Bill 376? Please remember to state and spell your name for the record.
Good afternoon, Madam Chair and members of the committee. Leah Cartwright, Leacartwright, here today on behalf of APCIA, the American Property Casualty Insurers Association. There is a representative from APCIA on the phone. I would like to say APCIA is in support of this legislation. Can't wait to see how it comes out of legal. Appreciate your hard work on this. I know insurance law is everybody's favorite. So I'll keep it short and simple. We think this will provide an opportunity to bring potentially new business to Nevada and will help homeowners or potential homeowners like myself who are unable to close on their real estate deals because you can't currently get insurance. So just a note of disclosure there. Hopefully none of you are having that issue, and we hope that this helps solve some of that. Again, to some of your points, this is an accessibility issue at this point. This bill addresses accessibility of insurance, not necessarily the cost, but once we get insurance to Nevada, then we can look at addressing rates. Thank you.
Good afternoon, Chair Marzola and members of the committee. My name is Jesse Wadhams. That's Jesse Wadhams on behalf of the Nevada Insurance Council. We are here also in support of AB 376. Want to appreciate Member O'Neill for bringing forward the bill, and we really appreciate Commissioner Kipper for working through and presenting a number of these additional amendments, particularly with the amendments. AB 376, I think, is attempting, as you heard, it's attempting to create options for coverage availability in property, particularly in a very changing environment. Providing carriers and consumers these options it's intended to open and make additional market segments available for property ownership. So we look forward to continuing to work with the Commissioner and Member O'Neill on the bill as it moves forward. Thank you.
Good afternoon, Chair Marzola, members of the committee. For the record, my name is Cadence Matijevich, Cadencematijevich, representing Washoe County. As you've heard today, the availability of and affordability of property insurance is an issue in Washoe County, and finding solutions to this is a priority for our Board of County Commissioners. In fact, they just asked Mr. Kipper to give them a presentation just last week to better understand the issue. We think that AB 376 brings forth solutions to this problem, and particularly I want to point out the provisions that are regarding HOAs. You heard a little bit today about town halls in Incline Village and Arrow Creek, and I want to caution perhaps those listening, the members know this, but issues in Incline Village, sometimes people think of those as issues of the 1%. And in this case, that's not the case. At that town hall, we heard heartbreaking stories from senior citizens who lived in the community for 50 years, who were at risk of losing their homes because they couldn't get property insurance. Workforce housing is a major issue in Incline Village, and HOAs are really one of the only options. And so addressing this is really important. We thank Assemblymember O'Neill for bringing the bill and urge your support. Thank you.
Thank you for your testimony. We also heard a lot of the homeowners' testimony during Interim Commerce and Labor Committee. So it is a problem for everyone, not just the 1%. You are correct. Is there anyone else wishing to testify in support? I don't see anyone. Is there anyone in Las? You're already sitting. You may begin when you're ready.
Thank you very much. Chair Marzola, members of the Assembly Committee on Commerce and Labor. My name is Anahit Baghshetsan. For the record, that is ANAHIT-BAGHSHETSYN, and I'm a research assistant at Nevada Policy. Nevada Policy is in strong support of AB 376 to establish regulatory sandboxes for property insurance. There are mainly three reasons which we have backed by our own research as of last year. First and foremost, Nevada ranks as one of the top 10 states with the most complex statutory codes in the nation. If you would like to refer to the complexity and the total number of other regulations we have as a state, please please feel free to refer to the exhibit that was submitted to the committee earlier. But while regulation undoubtedly plays an important role in consumer protection, we believe that it also has the power to limit the consumer choice. But this bill provides kind of a balanced and a carefully balanced solution where we would allow innovation and new policies while being under the oversight of the insurance commissioner, Mr. Kipper, who we heard from today. Second, the barriers also kind of prevent the innovation in states such as Kentucky, West Virginia, Utah, Vermont, where we've seen insurance sandboxes applied. We've also seen innovative insurance policies such as peer-to-peer insurances or AI and machine learning applicability into insurance policies, as well as on-demand insurance. So these are all policies that could potentially be implemented in Nevada for property insurance if needed. And lastly, the sandbox provides a break from government regulation, but a break from government regulation doesn't mean a break from market regulation. So if passed, this would ensure that the market itself decides which policies and which actors are the most powerful and which cater to the needs of the public the best. So for these reasons, we urge the committee to support the bill, and thank you very much for your time today.
Thank you for your testimony. I don't see anyone else in Las Vegas. Broadcast, is there anyone on the line wishing to testify in support?
Thank you, Chair. To testify in support of Assembly Bill 376, please press star 9 now to take your place in the queue or raise hand in your Zoom window. Caller, you're unmuted. Please proceed. Please ensure that you were unmuted on your end. Caller, with the last 3 digits, 587, you are unmuted. Please proceed and ensure that you're unmuted on your end.
Hello, my name is Christian Ratai, spelled Christian, last name Rataj. I'm with the National Association of Mutual Insurance Companies. And I'd like to thank you for this opportunity to provide brief testimony here. First of all, we agree with all of the comments and support that have been provided so far. NAMIC is conceptually supportive of the proposed legislation and appreciates the extensive work that the bill sponsor, Assemblymember O'Neill, and the Commissioner of Insurance, Scott Kipper, have invested into this project to assist insurers in having greater flexibility in the regulatory process so that they may better address consumer needs. Because that's the goal for insurers, is to address the needs of consumers. We just recently received a written copy of the proposed amendments, and we're reviewing them right now, and will provide additional feedback. What we've seen so far and what we agree with clearly is that the proposed legislation and the submitted amendments are intended to help streamline and economize the rate review process and provide insurers and their consumers with options, new options that will promote pro-consumer market competition between insurers and assist insurers in their ability to offer new innovative ways to address evolving needs of the consumer. As stated earlier by, I believe, the Nevada Research Organization, this proposal does provide a nice balance between regulatory oversight and market oversight. Therefore, we are supportive of the bill, and thank you for your time and effort on this.
Chair, there are no additional callers choosing to testify at this time.
Thank you. We will move to testimony in opposition of Assembly Bill 376. Is there anyone here in Carson City wishing to testify in opposition? Don't see anyone walking up. Is there anyone in Las Vegas? Broadcast, is there anyone on the line?
If you would like to testify in opposition to Assembly Bill 376, please press star 9 now to join the queue. Michael DeLong, you are unmuted. Please begin when ready.
Thank you very much. My name is Michael DeLong, Michael DeLong, Delong, and I'm a research and advocacy associate from the Consumer Federation of America. We strongly oppose AB 376, which would gut Nevada's insurance regulation, harm consumers, allow insurance companies to more easily raise rates on Nevada homeowners, renters, and motorists. Our testimony, unfortunately, is based on the original bill because we only heard about the proposed amendment this afternoon. And so I'm going to try and switch back and forth critiques. Basically, the original bill, AB 376, gutted Nevada's consumer protection laws concerning insurance prices and practices. It both allows insurance companies to raise rates without any review by the Division of Insurance, and it allows insurance companies to use Nevada consumers as their testing grounds for unregulated insurance products. It's kind of a shoot first, ask questions later approach that would increase premiums and put consumer financial security at risk. Under the original bill, an insurance company could increase its rates however high and however often it wanted and charge its consumers the new rate without waiting for the division's assessment of whether or not the rate was excessive, inadequate, or unfairly discriminatory. And even if the division found that insurers were overcharging consumers, it couldn't order insurers to refund the overcharges to consumers, and insurers could keep filing and using new unapproved rates. So while this amendment, from what we can tell, and we're looking at it very quickly, lessens some of the terrible provisions of the original bill, such as reducing the scope of the sandbox and having a flex rating, it's still a bad attack on consumer protection. It undermines Nevada's insurance rate review process. And we found that flex rating systems are quite harmful to consumers, with insurance companies often raising rates just below the threshold for regulatory approval without much oversight. So allowing insurance companies to exclude wildfire coverage would be a very bad idea, leading out to hollowing out of insurance policies. Insurance is supposed to protect people against disasters and crises. And Nevada has faced several years of rising insurance rates, but destroying the consumer protections built into Nevada law, as AB 376 proposes do, will only make the insurance crisis worse. So we urge you to oppose AB 376. We hope there will be more time to look at the amendment and
Sir,
look
can
at
you
it.
please
Happy to answer
finalize
any questions.
your testimony?
Yes, just finished. Thank you.
Thank you. Perfect timing. Broadcast, is there anyone else on the line?
Chair, there are no callers choosing to testify at this time.
Thank you. We'll move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? Oh, people are getting up, so I'm giving you time. I don't see anyone walking to the table. Still don't see anyone in Las Vegas. Broadcast, is there anyone on the line?
If you would like to testify in neutral for AB 376, please press star 9 now to join the queue. Chair, there are no callers choosing to provide testimony at this time.
Thank you. Assemblymember, would you like to give any closing remarks?
I'm going to let Insurance Commissioner Kipper give the first one concerning the fiscal note.
Hey, good afternoon again. For the record, Scott Kipper, Insurance Commissioner. This does have a fiscal note on it. In working through the issues, we will do what we can to take that fiscal note off.
And Chair, I'll just say thank you to you and to all the committee members for your consideration in listening to us today about AB 376. The passage of the bill will benefit Nevadans by fostering innovation, potentially leading to a better insurance product and services, while ensuring consumers protection through control, testing, and regulatory oversight. Thank you very much.
I will now close the hearing on Assembly Bill 376. I will now open the hearing on Assembly Bill 407. This measure enacts provisions relating to the repair of certain devices. Welcome, Assemblymember Brown May. You may begin when you're ready.
Good afternoon, Chair, Vice Chair, committee members. For the record, my name is Tracy Brown-May. I am proud to represent Nevada Assembly District 42 in Clark County. I want to first thank you for the opportunity to present this very important measure. I am joined today by Mr. Connor Fogel, and you'll hear from him. He is a self-advocate and amazing artist. Is that, yes, okay, that's good. You'll hear from Connor shortly. He's going to tell you a little bit about his story. I want to make sure that you have the correct measure that we're looking at. So it's Assembly Bill 407, version 3. This is what you all should have. The original bill, we completely reworked. So what you're looking at and everything that we're going to talk through, we're here on version 3 of Assembly Bill 407, which was the amendment that was both delivered and is available for members of the public here. Okay? Good, okay, thank you. Okay, so I guess it's really important to first determine why we're here. We've talked about right to repair on numerous occasions in the course of this legislative body. This measure really addresses the right to repair a personal mobility device. That's not where we started, right? First, Connor and his story is really why we're here and what perpetuated this measure. And then we really looked at broadly, what does right to repair look like? And then we pared it back, which is why we have this amendment now. So we have engaged a number of individual interested parties throughout the course of our entire community with regard to right to repair. But it's really important that you first hear about what it is that we're talking about. So I'm going to introduce to you Mr. Connor Fogel, and he's going to talk to us a little bit about his personal journey and his story.
Hi, Madam Chair, community. My name is Connor Fogel. My elected chair broke about 4 years ago. And I threw my whole life upside down because I was forced to use a manual chair, which I can't push on my own, and it is super uncomfortable. Lots of pain. Also, can't do my daily tasks. I'm here today because this issue is much bigger than most people realize, and they do not understand that we use our kids for our needs. And I was fortunate that I could do my job from home, because otherwise I would have lost my job because I can't do it without my kid. I do have friends who be in the same situation and they lost the jobs they're getting I can't think of the word. they're immobilized because they don't have the support and need from the chair.
Great.
Thank you.
You good?
Yeah.
Thank you, Tracy Brown May, for the record. As you can hear, this is a very big issue. Connor is a typical man who wants to be in his community. And when his chair breaks down and he doesn't have access to repair, he can't leave his house. He relies on other people to help him with mobility so that he can get out to work. He is not alone. It is very common for people who utilize mobility devices, personal mobility devices, to experience this. So he came here today to share his story and with all of us so that we can understand, as a representative from this community, why it's so important. So thanks, Connor, for being here. With your permission, Chair, I'll walk you through the proposed language that we have. This bill specifically is addressing wheelchairs, and that is the only item listed under equipment. It is wheelchairs and personal mobility devices. It is intended to remove the barriers for non-existent repair for those personal mobility devices. The original bill language has been gutted, and the bill is narrowed to address only personal mobility devices or wheelchairs. In the course of discovery, we met with many interested parties. The language is now modeled after other states where this work is already being done. So we're not reinventing the wheelchair, if you will. It's good work. Section 1 identifies Chapter 597 as that is our focus. Section 3 identifies that each definition as referred to in this measure. Section 3, sub 7 identifies equipment as mobility devices, and this is, again, the only equipment that we're referring to in this measure. Section 4 details fair trade practices. An original equipment manufacturer shall, on fair and reasonable terms and costs, make available to any independent repair provider or owner, which is also identified in the definitions, the original equipment manufacturer's equipment, any documentation, parts, embedded software, firmware, or tools that are intended for use with the equipment for any part, including updates to documentation, parts, embedded software, firmware, or tools to enable repair. Section 5 details what an original manufacturer may not retaliate against an authorized repair provider or hinder the ability of an authorized repair provider to provide or sell documentation, parts, or tools. Additionally, a manufacturer may not condition or impose an obligation or a restriction that is not reasonably necessary to enable an independent repair provider or owner to diagnose, maintain, or repair a covered product. Section 6 identifies protections for the manufacturer, because trade secrets need to be protected as well. Section 7 details liability, and that is really the entirety of the bill. I think we've done some really formidable work in this area, specific to ensure folks like Connor have an opportunity to get out. I do believe that we also have a member of the Attorney General's office here with us today, as they helped with a proposed amendment that simply states Section 8, a violation of the provision in Sections 2 through 7 constitutes a deceptive trade practice. So if you have questions relative to that, the Attorney General's office should be here. There is on page 6, Section 6, sub 6, there is a deletion in that language because it does not apply to wheelchairs. It was an oversight when we did the original amendment. And then we forgot a definition on page 4, item 21. So we propose to add a new item 21. And authorized repair provider, there was simply under section 3 on page 2, there was a piece missing. And that is the entirety of the bill. We're happy to stand for questions.
Thank you, Assemblymember, for your presentation. Thank you, Connor, for being here with us today and sharing. We really do appreciate it. And I keep hearing that you're this amazing artist that painted a mural, and it is gorgeous. I can't even draw a heart. And with that, we will start with questions. Assemblymember Anderson.
Thank you, Chair, and it's nice to see you again, Connor. It was lovely talking with you earlier. Thank you for bringing forward this bill. I think it's very important. I know you've been working on it for a few years now. My question actually has to do with Section 9, with the decision to have the act become effective January 1st instead of October or even earlier if possible. So just wondering if you want to go into the time frame as to why it was a little bit later.
Thank you. Tracy Brown May for the record. Other than it was a date that was just picked so that we can make, there was no specific thought process. I mean, I'm happy to make it effective as soon as possible.
Assemblymember Torres Fawcett.
Thank you, Chair. As you would know, I'm a big fan of right to repair legislation. I think it's about time that, we are able to fix our stuff, right? I think that becomes the ultimate challenge is, you have these devices that are worth hundreds and thousands of dollars, and then you can't repair it, and you can't get the information that you need to fix it. So I'm just wondering if you could be a little bit more specific, like what is going on right now when somebody tries to repair their wheelchair, and how will this specific legislation change that?
Connor Fogel for the record.
Yeah. So we're not allowed to fix our own chairs because there's just a rule for that, and if we're able to do that, that would make the time go by a lot quicker. Yeah.
Good.
Yeah.
I have a quick follow-up. Thank you, Chair. And do you know about how much money this could save, or like how much is it for somebody to just replace, or like what does that look like right now on average when somebody's trying to repair one of these devices versus replacing?
Thank you, Tracy Brown May for the record. Thank you for the question. It could be potentially thousands of dollars because we are not just fixing the wheelchair quickly with parts that are immediately available, right? Which then helps so then it immediately helps the person. So first of all, it supports small business because small businesses are able to open up and now instead of, and I'm gonna just pick on probably the age old, the Maytag repair person, right? That only has the Maytag parts, right? You now have an independent provider, like an independent small business that can fix and maintain mobility devices that are lots of different brands, which is helpful. So they carry the parts, they're able to do it in a more cost-effective way. It decreases the impacts to insurance if you allow people to be able to just do immediate repair. But then more importantly, it allows the person that utilizes the personal mobility device to get back to work. So we're putting people in jeopardy of losing their jobs because they don't have mobility, which then increases lots of other things and reliance on other social service or social, welfare programs because they are now just at the mercy of the repair provider. So Connor himself has spent an exorbitant amount of time just waiting for a part to come in where he did not have access to personal mobility, right, which makes everything more difficult. So you decrease the reliance on personal care attendants as he can be independent and mobile. Is that true? Yes. See, that's true. I hope that answers your question.
Committee members, any additional questions? Assemblymember Cole.
Thank you very much for being here, both of you. So I read the original bill. I haven't read the amendment, so I apologize if it's already in here. But I know in the original there was discussion about the warranty, that if somebody were to go in and do the repair on their own, it doesn't void any of the other warranties on any other aspect of the chair. And I just wanted to make sure that that's still in the amendment. Thank you.
Thank you. Tracy Brown May for the record. We do believe that we've still left the original warranty impact for pieces and parts that are not impacted by a potential repair. So you should still find that in this measure.
Assemblymember, I believe the amendment version 3 is on your desk as well. Okay, perfect. Committee members, any additional questions? I don't see any. So we will move for testimony in support of Assembly Bill 407. Is there anyone here in Carson City wishing to testify in support?
Thank you, Chair, Assembly Room. Sorry, I'm nervous. I just want to make this short and quick. I'm sorry. My name is Pam Barrick, Pamberek. I support the amended version of AB 407. Obviously, we run into the same problems that Connor has in the past. Things as simple as a footplate for him have broken, and we've waited 10 months to get another footplate, and that's insane. This is how we get him around. I can't carry him, I can't lift him. He can drive independently. I'm driving for him because I don't want anything to be ruined here, but it really takes away the mobility of the people that are relying on wheelchairs. And if you can imagine, somebody saying, oh, I'm sorry, you're just not going to be able to leave your house for the next year until we get this part, over something so little and so minute that you just want to scream. It seems like, to me, a no-brainer that this should be already out there, that we should be able to do a quick fix on a wheelchair. My husband's an engineer, and he's like, I'm so frustrated, I want to take duct tape and super glue sometimes just to fix things, but we don't want to void anything. So I am just here in support of this bill, the amended version, and I do hope you consider it. It passes sooner than January 1st. So thank you very much.
Thank you for your testimony, and thank you both for taking the time to be here today. You may begin when you're ready.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Mary Przinski, Pierczyynski. Mary is much easier, isn't it? Yeah. And I'm here representing Opportunity Village of Las Vegas, and also SNAP, which is the State of Nevada Association of Providers, and we're in strong support of this bill. Aren't we lucky we could all walk in here, with the exception of 2 people in the room who could not? And we don't think about it. We don't think about not having our mobility. But when you see the problems that people have, you're in a wheelchair and you wait weeks to get someone to fix it or to get the parts, it's just deplorable. So we're in strong support of this bill, and we want to thank the Assemblywoman Brown May for bringing it forward. Please pass this bill. Thank you.
Good afternoon, Madam Chair. Good to see you, members of the committee. For the record, Trey Abney, Tray, ABNEY, here today representing the hardworking job creators of NFIB Nevada, small business job owners. I want to thank Assemblymember Brown May and Connor for bringing this bill. Like Assemblymember Torres Fawcett, NFIB is a strong supporter of right to repair legislation in general, and we think that small business owners in our own communities are more than capable of doing quality repair work quicker, cheaper, and with better customer service. So we appreciate this bill, and we hope you pass it. Thank you very much.
Thank you for your testimony. Please remember to state and spell your name for the record.
Hi, my name is Brian Edom, Bryaneidem, last name. I am Connor's coach. I'm in the Hall of Fame of Natural Bodybuilding, and Connor's actually the world champion right now for natural bodybuilding in the physically challenged division. I have 3 athletes that are quadriplegics. We provide free training for them, and personally seeing what happens when they are without their wheelchairs, when they have to send it in for simple repairs. It could be months that the wheelchair is gone and they're stuck. And one of the benefits that they have extremely active lives, and it takes muscle memory to continue those activities every day. When you're sedentary for that long on a manual wheelchair that they physically cannot operate, this is very, very important for them to have the opportunity to not only get the proper equipment needed to repair them, but to make those simple adjustments. And we do have enough, strong enough, I've learned it firsthand, we have a beautiful state, a beautiful community of people that are willing to surround Connor and surround other quadriplegics and get these simple fixes done without ruining the integrity of the wheelchair or losing that much needed insurance that is to repair. So I'm in favor of this bill, and I implore you to please vote yes. Thank you very much.
Thank you for your testimony this afternoon. Is there anyone else wishing to testify in support? I don't see anyone. I don't see anyone in Las Vegas. Broadcast, is there anyone on the line?
Thank you, Chair. If you would like to testify in support of Assembly Bill 407, please press star 9 now to join the queue.
Good afternoon, Chair and members of this committee. My name is Catherine Nielsen. I'm the Executive Director of the Nevada Governor's Council on Developmental Disabilities, and we are extremely pleased to offer strong support of this measure today. This issue is not just about consumer rights, it's about dignity, mobility, and independence for individuals who rely on power and manual wheelchairs for daily life. They're essential medical devices. They are more than just equipment. They're a person's legs. Imagine asking these repair companies to go without their legs for 6 months to a year. That is reality for far too many wheelchair users who are left waiting for essential repairs. No one should have to endure such hardship due to unnecessary repair restrictions. And the right to repair law would address these issues by ensuring that wheelchair users and independent repair providers have access to necessary parts, tools, and diagnostic information. And one of the major issues that we've encountered also relates to providers failing to meet the minimum requirements needed in order to fill out the paperwork when it comes to durable medical equipment. And we are working hard with a group of parents to rectify those needs with the Board of Pharmacy. And so we're extremely excited to see that the Assemblywoman's measure will just strengthen all of the efforts that we have put forward to ensure that we can reduce the amount of time it's taking individuals to get their wheelchairs repaired. So thank you so much for your time, and we wholeheartedly support this measure.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Thank you, Chair. There are no additional callers choosing to testify at this moment.
Thank you. We will move to testimony in opposition of Assembly Bill 407. Is there anyone here in Carson City? I don't see anyone. There's no one in Las Vegas. Broadcast, is there anyone on the line?
If you would like to testify in opposition to Assembly Bill 407, please press star 9 now to join the queue.
Good day, Chair. This is Dora Martinez. I actually wanted to testify in favor, but I got my code backwards. May I please proceed?
Yes, Ms. Martinez, go ahead. We will move back to support testimony. You may begin when you're ready.
Oh, you're super awesome. Thank you, Chair and members of the committee. Thank you to Tracy Brown May. Thank you, Madam Assemblywoman Tracy Brown May. You've always been there for people with disability, and we appreciate you, and we wholeheartedly hope that you could all support this important bill. Thank you. Bye-bye.
Thank you for your testimony. We'll move back to testimony in opposition. Broadcast, is there anyone on the line?
Chair, it appears there are no callers choosing to testify at this time.
Thank you. We will move to testimony in neutral. Is there anyone here in Carson City wishing to testify in neutral? Don't see anyone walking up. Still no one in Las Vegas. Broadcast, is there anyone on the line?
If you would like to testify in neutral for Assembly Bill 407, please press star 9 now to join the queue. Again, to provide neutral testimony, please press star 9 now. Caller ending in 766, you are unmuted. Please begin when ready.
Thank you, and good afternoon, Madam Chair and members. My name is Mark Orada, O-U-R-A-D-A, and I am a Director of State Government Affairs for the National Electric Manufacturers Association. It is a association represents over 300 leading manufacturers of electrical technologies. And with over 50 product lines, we are impacted by all kinds of legislation, including legislation such as this on wheelchairs. As a former Senate member, I remember well discussions of unintended consequences. So I'm always on the lookout for a greater definition to avoid those kinds of pitfalls. Fortunately, I don't have the amendment language in front of me. I'd like to say, first of all, to the author, thank you for all the good work that you've done on this legislation. A couple of concerns I wanted to highlight, if they are still relevant given the amendment in Section 6, is the definition used there and how it may impact lighting products, specifically what we would term now as smart lighting. So concerned about potential fallout from that. In Section 30, more specifically, we would suggest it would be advantageous to clarify that in simply not using the term trade secrets, but intellectual property that would include patents, trademarks, and copyrights. And that would, we believe, cover more issues that may come up as opposed to the less definitive language there. So that's all we have to say at this point, Madam Chair and members. Again, thank you for the good work, and we look forward to working with the Assemblywoman on any further potential edits.
Thank you for your testimony, sir. I would recommend you reading the amendment number 3. I believe that it addresses some of your concerns. Broadcast, is there
All
any?
right, thank you. I don't have it available here. So.
No problem. It's on Nellis, so if you want to pull it up, that'd be great. Have a great afternoon. Broadcast, is there anyone else on the line?
Thank you, Chair. There are no callers choosing to provide testimony at this time.
Thank you. Connor, Assemblymember, would you like to give any final remarks?
Connor Fogel for the record.
Just wanted to thank you for even looking at the bill, because this been a very long, hard road. So thank you.
Thank you. Tracy Brown May for the record. First, I want to thank you for the opportunity to present this measure. As you can see, it's very necessary, and there are a lot of people that are depending upon us to be able to have access to our community. Secondly, I would love to say that we are absolutely open to an amendment to move our date forward to upon passage and approval. So we're happy to entertain that option, and please feel free to reach out if there's any additional information we can provide. Thank you, Chair.
Thank you, Assemblymember, for bringing this bill forward, and if you want to get that amendment to us right away, that would be great. Connor, again, it was great to meet you. Thank you for being here in this crazy weather. I will now close the hearing on Assembly Bill 407. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Public comments limited to 2 minutes per person. Please remember to state and spell your name for the record. Is there anyone here in Carson City wishing to provide public comment? I don't see anyone in Las Vegas. Broadcast, is there anyone on the line?
If you would like to provide public comment, please press star 9 to take your place in the queue. Chair, the public lines are open and working. However, there are no callers to provide public comment at this time.
Thank you. Members, are there any comments before we adjourn? I don't see any. One day. And with that, this concludes our meeting. Our meeting's adjourned.